Welcome, everyone. Thank you all for joining us today. My name is Gershon Margolis. I'm the founder of Imperial Advisory Outsourced CFOs. I'm pleased to be joined today by Bob Doyle, my partner and another one of our CFOs. And let me take a moment to tell you about Imperial Advisory, and then I'll introduce our speaker. So Imperial Advisory, we're a group of CFOs. Like I said, we go into businesses, smaller businesses that do not have a CFO. We serve as the CFO, and we're the best friend of the CEO, as Bob likes to say. And so we enable smaller businesses that have complicated issues but don't need a full-time CFO and otherwise wouldn't have access to it. So we enable them to have access to that level of expertise. And then we also work with larger businesses that do have a full-time CFO, and sometimes that CFO is overwhelmed. You know, they've got legal and HR and real estate and accounting and 14 other departments reporting to them. We help extend their bandwidth. And we've got a team right now, 3. Within the next week or so, we'll be up to 5 CFOs. I'm the anomaly. The rest of them have a little bit more gray hair than I do, decades of experience running ginormous companies. And anyway, it's a wonderful group, and we're glad to get to know you. Today, I'm very excited to have Doug Rowe as our guest speaker. I've gotten to know Doug. He's come highly recommended, and we've had a number of very interesting conversations. And when I'm guessing he offered, but maybe I invited him, I don't recall. Either way, I was very pleased to have the opportunity to host Doug here today. And Doug is going to speak to us about something that's probably on many of your minds, which is, how do I not get sued? Or no, I don't know what he's going to say. He's going to tell us about solutions to some of the issues that come up with work from home. So without further ado, Doug,
sure.
Welcome.
Thank you, Gershon. So it's working from home has unique issues, and you would think that all the issues that exist in the physical workplace in an office are essentially the same at home. And that's true, except employers are really not aware of that fact. And because the home is different than the office, employers have to be aware of the issues in order for them to adapt their operations so as to stay in compliance and avoid the liability. And the potential liability for not being in compliance is significant. So what I've done is I've done this talk before, and there are literally many issues involved in working from home. I'm going to start with wage and hour issues. So in the workplace, an employee comes in, they sign on their computer, they punch a time clock, they punch out for lunch, they punch back in after lunch, they punch out at the end of the day. That's what the physical workplace looks like. Well, employers have to track their employees' work time in the same manner when they work from home. The problem is that, number one, there's no time clock. Number two, there's not necessarily the same sign-in capability that exists at home than exists in the office. And because employees work from home, they may look at their workday differently. So an employee may feel that they can start work at 9 o'clock, work till 10, take a 2-hour break, skip lunch, work 3 hours in the afternoon, take a 3-hour break, make dinner, take care of the kids, then work 3 hours at night, and get in their 8-hour day. And that's all well and good for the employee, but it's not necessarily well and good for the employer. Why not? Because number one, the employer doesn't have the ability in that scenario to truly track the employee's time. So is that employee working 7 hours that day or 9 hours that day? Is that employee also deciding that after that work day, they forgot to send out some emails and they go back on their computer at midnight and spend another half hour on their computer? Well, that's compensable work time for an hourly employee. So it's important for the employer to set up a schedule for the employee that the employee will follow in order for the employer to ensure that employees are being paid for all compensable time, and that the employer is not facing a situation where there's an overtime claim because the employee, again, is working off the clock at night and on weekends. So it's incumbent upon the employer to set a schedule for the employee, to potentially work with the employee as to what that schedule will be if that employee has, certain childcare needs, at home to address. But again, it's important to establish boundaries, set schedules. And by the way, in New York, for example, employers are required to provide a meal period for employees. Well, they have to track the meal periods also, because if they don't, there could be a claim that the employee has that they were not provided the proper meal period. There's also a law in New York, and I'm going to mention this by way of example. There's a law that's unique in New York. It's called spread of hours pay. Spread of hours pay entitles an employee to an extra hour at the minimum wage for every day where their hours exceed 10. So, and when I say exceed 10, that doesn't necessarily mean work time. It means where their hours spread over more than 10 hours in a day. So you could have an employee who works 3 hours in the morning, takes a 5-hour break, works 3 hours at night. That employee has only worked 6 hours, but because their hours spread over more than 10, which is 11 in this case, that employee arguably is entitled to spread of hours pay. It doesn't make any sense. That employee has only worked 6 hours, but the potential liability where the employer permits the employee to work schedules like that is monumental. We're actually dealing with a case right now where there were several hundred employees whose hours spread over more than 10 hours every day for over a 6-year period. And the potential liability is in the low 7 figures because the employer was not aware of spread of hours pay and didn't pay the employees an extra hour at the minimum wage for every day. And by the way, when you don't pay an employee this proper spread of hours pay, you also owe them liquidated damages, which is essentially double the amount of the unpaid spread of hours pay. So again, spread of hours pay is another reason why employers need to set schedules for their employees and track the employees' time. Employees in New York are also entitled to be reimbursed for their expenses. Now, needless to say, when an employee works at home, they're going to be potentially faced with incurring expenses in behalf of the employer. Buying paper, buying printer cartridge. These are all potentially expenses that are reimbursable. And there are the cases in New York that stand for the proposition that and let's assume it's a minimum wage employee, where a minimum wage employee is not reimbursed for expenses, essentially they're being paid less than a minimum wage. And because of that, that could constitute a minimum wage violation where the employer becomes liable to the employee for the underpayment of the minimum wage, as well as I said before, liquidated damages and potential attorney's fees. So again, that's another reason why the employer has to pay attention to this, has to reimburse the employees for, any expenses they incur. And, these issues can be dealt with, by the way, with a work from home policy. So the employees are aware of their obligations, and so the employer will notify the employee of what's expected of them. It's also incumbent upon the employer, depending on the size of the employer, to train supervisors to be aware of these issues so that everybody's on the same page with respect to compliance with the wage and hour laws. We've all been in offices in cafeterias and offices where we see the labor law posters. There's state minimum wage posters, there's federal minimum wage posters, there's state workers' comp posters. There are probably a dozen or so posters that exist and/or notices that employers are obligated to give to their employees. Well, what happens if an employee works from home? Well, the Department of Labor recently issued guidance indicating that electronic notice and/or electronic posters are permitted if the employee customarily receives information by electronic means and has readily available access. So again, it's something for the employer to be aware of. And again, if the Department of Labor comes in to audit an employer, they're going to be looking for the posters. That's one of the items that the Department of Labor typically looks for. If they don't see the posters are posted or they haven't been sent to employees by electronic means, or the employee hasn't received the sufficient notices, then there's going to be a fine. It's going to be an automatic fine issued by the Department of Labor. The Department of Labor has actually recently, probably in the last few months, issued a guidance which sort of is a gift for employers. Similar to the spread of hours pay issue that I mentioned before, there's a concept in wage and hour law called the continuous working day rule. So if an employee starts their work at 9 o'clock, starts their day at 9 o'clock, works 3 hours at home, and then drives to work, drives to the office that same day. And let's assume that it's an hour commute time. Well, under the old rule, that commute time is compensable because the employee has worked a continuous day from 9 o'clock, presumably till 5 or 6 that afternoon. With that said, there's also a rule by the Department of Labor which indicates that employees are not entitled to be compensated for their commute time. So now you have the continuous day rule, which flies in the face of the lack of compensability of the commute time. So the Department of Labor recently has issued guidance that indicates that commute time in the middle of the day is not compensable, even though it's part of the continuous workday. So it's just something for employers to keep in mind. As I said before, probably the most important takeaway on the wage and hour side with respect to work from home issues is have a written policy. Make sure you train your supervisors to ensure that the employees are compliant, and make sure you're tracking the employees' time. And again, one of the important takeaways also is it's probably the best practice to have the employees sign an acknowledgement on a daily basis as to what their hours were, what their start time was, what their end time was, what their meal period was. That way the employee is acknowledging what the hours were, and it won't come as a surprise later if it turns out that there's a potential significant overtime claim. As long as the employer is aware of what the employee is doing and the employer is paying the employee the hours worked, then there shouldn't be an issue. But it's important for the employer to keep track of the hours, and the employee should also be involved in that process by reporting their time on a daily basis. Any questions about wage and hour issues involving work from home?
At what point can now the way people get recruited for jobs varies, as we know, so at what point is this sort of an upfront discussion after you make the hire, or do you suggest that the employer build this into the qualifiers for getting the job?
Well, it depends on the employer's needs, and if the employer's expectation is that the employee is going to work from home, then that should be part of the offer letter, and as part of the offer letter, the work from home policy could be distributed. It's a function of meeting the expectations. Many of the work from home issues come up in the context of, you have employees who are already employed, and then COVID hit, and then the employers were shifting from, office work to work from home work. But if for new hires, it's just, meeting the expectations, disclosing what's the expectations, and,
Yeah.
and dealing with it on that basis.
Yeah,
Yes.
I put a question in the chat. I had, during the past year, I have conversations with friends who work in various types of associations. One was a not-for-profit, and specifically when they sent people home to work remotely, they were a little disappointed in his work performance. So what they did, they installed something on the computer, unbeknownst to him, that technically would track, I guess it's how many times he would log in and do the job. And I think they got wind that that wasn't legal or kosher. So
Um,
do you know anything about that?
Yes, that's one of my topics. I have many topics about working from home. Employers, I'll talk about New York now for a second. Employers in New York are entitled to monitor their employees' work. And if they don't disclose to the employee that they have the right to do that, the employee still wouldn't have a right to claim an invasion of privacy, because there are no privacy rights for employees in that regard. Nevertheless, it is the best practice for employers to disclose to employees that they do have the right to monitor the employees' work. They do have the right to monitor their productivity. There is software out there that actually enables employers to determine how many letters the employee is sending out on a daily basis for a second, on a quantifiable basis. There is software that enables employers to actually see the employee's computer screen while the employee is working. That's all legal in New York. But again, best practice and best advice is to disclose to the employee that you intend to do that. And then if the employer feels that if the employer feels the employee is not getting the productivity that's expected, warn the employee just like you would in the office. But that's kosher, that's legal in New York. Not necessarily in every state. I can't tell you what California does because
Right.
they are definitely employee friendly. But I even think in California, it's just about disclosure, and as long as the employer discloses
Right,
the fact that
right.
they have this right, that's fine, that's okay.
So when the employer, this is another scenario that's true, another employer, a large not-for-profit, everyone's now scattered working from home, they're asking their employees to track and report every 15 minutes of activity in some kind of document that then gets submitted to their supervisor. So an every 15-minute experience needs to be documented. Does that sound punitive? I mean, is that a norm for how people are functioning in the workplace today, given your experience?
It seems over the top. It seems unnecessary every 15 minutes. I just can't imagine, the employer is going to get the productivity on a daily basis that they would want to have if part of that day is spent, by the employee reporting back
Right.
to the employer on at that level. It doesn't make sense to me, but I could see reporting back several times during the day, but not necessarily on a 15-minute basis.
Yeah, no, it seems like,
I haven't seen that.
okay. Thank you very
And
much.
by the way, I gave this presentation to the nonprofit hub last week, and there were probably about 100 nonprofits there. Nobody raised that issue, so.
Oh, no kidding.
Yes.
Maybe because they're the leaders in the not-for-profit versus those who are employed in the not-for-profit.
Right.
Wow, wonderful.
Doug.
Thank you.
Yes. Yes, Gershon.
Quick question. I've got a question. If you have employees clock in and clock out multiple times, like just tell them whenever you work, clock in, does that skirt, other than the 10 hours time span, does that skirt most of these issues?
It does, as long as the employer understands what the employee is doing. It should really be about disclosure, and there should be a conversation, and based on the potentially the employer's needs and the employee's needs, again, perhaps childcare needs at home or taking care of a family member at home. I mean, that's really about disclosure. But again, that does raise the potential issue on the 10 hours. And from a payroll standpoint, I guess, it's probably a little more difficult to track, an hour work and an hour off, hour work and an hour off. It probably becomes a little bit of a bookkeeping nightmare. But as long as the employee is paid for all the time worked, and the employer understands that that's the way the employee will work, then it's okay too. Aside, as I said before, from that 10-hour issue.
Thank you.
By the way, I overlooked one issue on the wage and hour side, and haven't left that topic yet too. But when I talked about reimbursement of expenses, and I talked about copy paper and printer cartridge. There's actually a law in California that requires employers to reimburse their employees for the percentage of use of cell phones that's worked on for business purposes. So that's another aspect of reimbursement of expenses policies that employers should be aware of, depending on the state. So it's a state-specific law. It's not New York law. It's not federal law, but employers should look at the specific state requirements with respect to reimbursement of expenses.
So if you had a child and you needed childcare to allow you to function in your home office, would that be an expense that would be deductible, or is that something that the employee would have to incur?
That would be something the employee would have to incur. That would not be a reimbursable expense.
Right.
'Cause
So
the
your
employee-
presentation,
The employee could take a leave of absence if they need, because that's what the employee would generally do if they didn't have the opportunity to work from home. Which leads me to the next topic on working from home, which is working from home a reasonable accommodation? Does the employer have an obligation to enable an employee to work from home? So that issue comes up typically in the context of disability discrimination,
right.
for example. So if you have two employees working side by side and both ask if they could work from home, and the employer grants one request but not the other, and let's assume that one request is based upon some disability and the other request is just based on a preference or a generalized fear of contracting COVID-19 from their commute. Well, generalized fears is generally not a disability, whereas if the other employee had a true disability, for example, it could be asthma, or it could be something that would really prevent them from working in the office. It could be an allergy. It could be an allergy of wearing a mask in the workplace, something crazy like that. Then the employer would have an obligation. So if the request for a reasonable accommodation is made and it's based upon a disability, the employer would then have to engage in the interactive process of sitting down with the employee, talking to them about the need for the accommodation, determining whether the employee can perform the essential functions of that job while working from home, determine whether working from home will create an undue hardship to the employer. And if the employer is satisfied that all that can be done and the work can be done, the essential functions of the job can be done while working from home, then the employer would have to grant the employee that request for a reasonable accommodation. So that's the analysis. Again, it has to be based upon a disability. Also, employers have to be careful that they don't want to necessarily grant a request for working from home merely to a 70-year-old employee or a pregnant employee, because it's not up to the employer to determine whether to mandate working from home as a reasonable accommodation. It's up to the employee to request. So if an employer feels that, the vulnerable population, such as a 70-year-old employee or a pregnant employee, would be at greater risk by working in the office, well, that's discrimination. That would be a violation of Title VII, New York State discrimination laws, or the Americans with Disabilities Act, if the employer would mandate working from home as a requirement for the vulnerable population.
Doesn't the individual who's claiming a disability need to have a medical note that claims and corroborates their statement about the disability?
Yes, the employer could ask for a doctor's note. Yes.
Got it. Is most of this presentation tied to wage earners by the hour, or is this also transfers into the salaried worker, employee, professional?
It also, so it also ties into the salaried worker. And let me touch upon that in the wage and hour world. So if you have a salaried worker, first of all, let's remember that the mere fact that an employee is salaried doesn't mean they're exempt from overtime. So in order for an employee to be exempt from overtime, they have to fall within one of the exemptions, such as executive, like a manager, administrative, like an HR director, professional, like a lawyer, computer professional, like a software engineer. All right, these are the typical exemptions that we deal with. So if you have a manager, you mentioned salaried. If you have a salaried employee who is called a manager, but really doesn't supervise at least 2 full-time employees or have a right to hire and fire those employees, then that manager is not exempt, notwithstanding that they're paid a salary and notwithstanding that they are called a manager. And one of the issues that has come up in the context of COVID-19 is that because there have been layoffs, extensive layoffs in many companies, many different industries, the employers have reassigned many of the duties. So pre-COVID, if you had a manager who was exempt, but now you had layoffs, and now due to a reassignment of duties, that manager is now performing non-exempt duties. And let's assume that the non-exempt duties are now a majority of that employee's duties. That employee who was previously exempt, all of a sudden could be non-exempt, entitled to overtime. So again, that's another issue that arises out of the work from home context with employers. Again, it's another issue employers should be aware of.
Right. In addressing how you're framing all of this, are we assuming that the number of employees in a work environment is 50 or 100? If you're looking at a small, by example, if you're looking at a small employer, suddenly everybody now has to be held accountable. Who's ultimately responsible for the compliance on the matters that you're outlining? Is it the HR? If there's no HR, is the owner of the company? I mean, how does this trickle down?
Well, ultimately it's the employer's obligation to keep track of their employees' time and to pay for them for all time worked, and the employer has a record-keeping obligation. That's in the law. So the employer has to figure out how they're going to keep records of track the employee's time and keep records of the employee's time. And by the way, again, when I speak about this, it could be a 5-employee company. It could be a 50,000 employee company. Google has all their employees working from home right now. They have the same obligations to pay their employees for all time worked and to pay their employees overtime if they work in excess of 40 hours in a week. So they have the same record keeping requirements as the small employer.
Thank you.
Okay. Work from home issues as a reminder, employers have an obligation to not discriminate and to make sure that there are no discrimination claims. And if there are discrimination claims, to address them, such as sexual harassment or harassment based upon other classifications. As I mentioned before, there's been a rise in discrimination cases with respect to employers' treatment of the vulnerable population. So again, that's something that falls within this category. There's also as a reminder, and by the way, this should all be dealt with in the work from home policy, just to remind employees of the anti-harassment policies and the anti-discrimination policies in the workplace. But those policies, again, apply to employees who are working from home, and employees can harass other employees through email, through text messages, through through phone calls. So again, it's important to remind, for the employer to remind all their employees that the discrimination laws also apply when they work from home. The next issue is health and safety. Employers are obligated to provide their employees with a safe workplace. That's in the general duty clause of the OSHA regulations. Well, the home, think about the home now as the workplace. The employer has to provide a safe workplace even in the employee's home. If the employee trips over a wire on the way to the bathroom when they're working from home, that's a potential workers' comp claim, believe it or not. So we've had situations where, and we've advised employers when they have an extensive number of employees working from home, is that they should conduct some kind of review of the work space to determine whether it appears safe. It avoids the liability, it reduces the potential liability from a workers' comp standpoint. Also, with respect to safety and health, it's important for employers to be aware as to what general liability insurance they may have and whether their general liability insurance policies cover the home as the workplace. So if, for example, an employee is working from home and has a visitor who comes to the house and it's a business related issue, and that visitor trips and falls, well, is that general liability policy from the employer going to cover that injury? So again, with respect to working from home, it's important for the employer to coordinate those issues with their insurance carrier as well. Cybersecurity and trade secrets. When we're dealing with employees who work from the office, there's typically an IT department or an outsourced IT provider, and typically the computers will be set up to have whatever safety measures that are necessary to protect the company. But the employee's laptop may not necessarily have those same protections. So again, it's when you have employees working from home and they're working on their own computers, it's harder for employers to control. Needless to say, employers are potentially more vulnerable to data breaches when you have employees work from home. So it's again another issue that employers should be aware of and take whatever precautions are necessary to protect their confidential information, their trade secrets, their proprietary information, etc. And the next issue I already touched upon is monitoring productivity and communications. And again, as I said before, employers are entitled to monitor their employees' work And again, best way to do it is with full disclosure.
I got a couple of questions of just what you addressed. Two things. The fees to cover the cost of having your computer under like a McAfee security system or whatever those fees are to make certain the employee has the requisite security, that's considered an expense, correct?
It is.
Okay, and that falls on the employee, not the employer, correct?
Good question. That I would look at, and I would think that the employer is trying to protect their trade secrets, their confidential information. The expense would be on them, the employer,
Okay.
not
Okay.
the employee.
Okay, and then the other question is tied to liability. Tripping and falling is one thing, but if there's an errors and omissions option, is that something that the employee would also take out as an insurance policy, if you will? Or is that something the employer would have
I
for the
would,
employee?
it's basically the employer's obligation. It's the employee the employer would want to have that policy, would
Okay.
want to have that coverage. If there's an injury or there's some property damage, I can't tell you between the employer's general liability policy and the homeowner's policy, which one would pay out and which one would try to disclaim liability or point to the other. But I think from an insurance perspective, it's important for the employer to make sure they have the proper coverage for that situation. And then if the claim comes in, let the insurance companies fight it out as to which policy should pay out the potential damages.
Okay, yeah, there's a lot of complexities when it comes to working out of your house, so
Yes, yeah, exactly.
thank you.
Does anyone have any other questions about work from home issues?
We're dropped short on time, so I think it probably makes sense for you to go through whatever else there is, and then we'll push any other questions to the end at this point.
Okay. All right, so I am going to discuss, and this is sort of a bonus round, let's call it, vaccines in the workplace. That is the next hot issue on the horizon. Employers are debating whether they can require their employees to become vaccinated, to be vaccinated. And there have been several developments over the last few months on this issue. So the U.S. Equal Employment Opportunity Commission in mid-December essentially came out with guidance that stands for the proposition that that companies may have the legal right to mandate that employees get vaccinated for COVID-19. So why did they conclude that? They concluded that because they've determined that a vaccine is not a medical exam. Why that's important is that if the vaccine was a medical exam, employers would not be able to administer the vaccine or have a third party administer the vaccine under the Americans with Disabilities Act. But the EEOC has opined that because it's not a medical exam, employers are entitled to require their employees to take the vaccine. Employers should be aware, though, that it's one thing to require employees to take the vaccine. It's another thing to have employees fill out pre-screening vaccine questions, which could be a violation of the Americans with Disabilities Act. So it's just something to keep in mind that could violate the Americans with Disabilities Act, but the requiring the vaccine itself, according to the EEOC, is not a violation of the ADA. There are exceptions, of course. The EEOC has indicated that if the employee has a valid objection based upon a disability or a religious objection, then the employer has to engage in the interactive process with the employee to evaluate the request for the reasonable accommodation, to determine whether it is whether not requiring the employee to become vaccinated is a true reasonable accommodation, whether it's based on disability or religion. And then the employer has to conduct that evaluation. And if a reasonable accommodation is required, then the employer cannot mandate it, but there could be other reasonable accommodations associated with not requiring that employee to be vaccinated, such as permanently, so to speak, allowing that employee to work from home if the employer is concerned about having employees come into work in the office if they're not vaccinated. So there are different ways to deal with the request for a reasonable accommodation. With respect to the religious accommodation, employers should assume that the employee has a sincerely held religious objection if the employee has an objection based upon his religion. But it's not improper for the employer to question the employee as to the validity of the religious objection. That's not a violation of the Title VII. Can employers terminate employees for refusing to be vaccinated? Well, the answer is yes, but, as lawyers say, but maybe not. Why not? Well, there's an interesting issue with respect to the vaccines. So all the vaccines that have now been authorized are authorized under the FDA's emergency use authorization. And under the FDA's emergency use authorization, employers, if they administer the vaccine, are required to give their employees a fact sheet. And included in the fact sheet issued by the FDA is a statement that the employee or the person receiving the vaccine can refuse the vaccine. So now you have an issue where the EEOC has said that the employer can mandate it, and you have the FDA in their fact sheet that has indicated that the employee can refuse to have it. So if there were to be a lawsuit, if the employee was terminated for refusing to take the vaccine, I don't know how the courts would rule at this point. I don't know what law trumps which, whether the FDA law would prevail or the EEOC regulations would prevail. It's an issue to be seen. And again, it's too soon for these issues to have even gotten into the court system. There are practical considerations with requiring employees to take the vaccine. Should they? And if employees refuse to take the vaccine, should the employer terminate the employee? We've had a situation recently with a nursing home where most of the nurses were refusing the vaccine. The employer couldn't terminate all of them because they couldn't be replaced. And even if they were replaced, they probably would be replaced with employees who also would refuse to take the vaccine. So you have some practical considerations when you're dealing with the issue of whether employers should require their employees to be vaccinated. You also have employee morale issues. If you mandate vaccinations, how are the employees going to feel about that requirement? It could affect morale. There are potential workers' comp issues. If an employer requires an employee to be vaccinated and the employee has an adverse reaction, well, that potentially is a workers' comp claim. On the other hand, if an employee refuses to take the vaccine and then contracts coronavirus in the workplace, that's a potential workers' comp claim. The difficulty with those kind of claims is that, is that it's hard to prove a causal connection between the workplace and contracting coronavirus, but it's an issue to be aware of. And what about union companies? Most collective bargaining agreements state that the employer can't terminate the employee without just cause. Well, is refusal to take a vaccine, does that constitute just cause under a collective bargaining agreement? Again, there haven't been any cases, nor have there been any arbitration decisions that have come down this quickly on the issue, but it's something that employers should be aware of. We've seen also, there have been quite a few news stories recently about employers offering their employees incentives to take the vaccine, such as additional pay or additional time off. There are also some issues now as to whether that additional pay or additional time off constitutes pay that's subject to, that's taxable under these circumstances. So that seems to be an issue. I know SHRM recently has sought, SHRM is the Society for Human Resource Managers. They've sought, various opinions on the viability of offering of employers offering incentives to their employees. There are HR solutions for tracking vaccinations depending on the size of the employer. You could see the difficulty in employers tracking the employees to determine, whether employees have received the vaccine, when they've received their first one, when they need to receive their second vaccine. So if the employer is going to have a policy, tracking the vaccinations for their employees becomes an HR issue as well. And one of the big issues, and this is also one of the practical issues in requiring employees to become vaccinated, is that there are the slow rollouts and the different state requirements could affect the requirement for employees to be vaccinated. So needless to say, a 65-year-old employee can be vaccinated now, but a 35-year-old employee may not be able to be vaccinated for 3 months, who knows when. So, there are practical considerations, in requiring employees to become vaccinated in the workplace. Does anyone have any, and again, I'm just touching upon these issues. These are the issues that we see in vaccines in the workplace world, and I'm sure as time goes on, there's going to be other related issues. Does
Did you
anyone
ask
have
for
any
questions?
about that topic?
Yeah, I specifically had one tied to long-term adverse reactions to the COVID vaccination. People do return to work. They do suffer from fatigue, confusion, and some of the other things that people may not be speaking about. But would that at some point be something a workman's compensation issue can come from?
The answer is yes, if the employee can show that those, those physical effects are related to the vaccine. Again, it's a causation issue, but
Right.
if those are the after effects of receiving the vaccine and it was required by the employer, then that likely would be a covered workers' comp claim. If, on the other hand, the employee just voluntarily received the vaccine and then had these adverse reactions, that would not be a covered workers' comp claim.
Right. And if someone is looking for a job and one of the mandates is that they have to get a vaccination, is that kosher? Is that something they could ask and mandate?
Yes, they could ask that.
Okay. Just want to be clear. Thank you.
Yes.
Doug, we have a question in the comments. Bob is asking, how do you balance the right for a safe workplace with HIPAA? I suspect you can't disclose that someone refuses to take it, yet it seems your people have a right to know.
The answer is you can't disclose it. You can't disclose who takes it and who doesn't. You can't disclose who in the workplace may have contracted coronavirus. If there's a positive case, the employer should disclose to other employees that there was a positive case, but they're prohibited from disclosing who had the positive case. So again, there are confidentiality obligations that the employer will have. And, you know, oftentimes you have a situation where the other employees can figure it out, but the employer does have the obligation to keep confidential information like that as best they can.
Was that the last topic, or are we still?
That was the last topic. Does anyone have any questions about work from home issues or vaccines in the workplace? Or anything about labor and employment law?
What role does the unions play in speaking on behalf? Do you have any experience working directly with the unions, the trades, or the?
You know, well, I handle labor law as well. We get into collective bargaining, negotiation issues. We haven't yet faced with a situation where employers are, where unions are refusing to permit the employers to mandate a vaccine in the workplace policy, but I could see it happening. And,
Yeah.
you know, then you get into issues with, you know, whose rights prevail. Is there a management rights clause in the collective bargaining agreement? Is this a mandatory subject of bargaining? What would the National Labor Relations Board say if the employer mandated vaccines in the workplace without negotiating with the union? You know, these again are some of the issues that
Right.
would come up.
So that's the private sector. Have you done anything with the state agencies like the prison systems and the CSEAs and the people who have to kind of commingle with high risk and they're exposed and they're not given the vaccines?
We haven't had that issue yet. We do have a public sector union practice group here where we deal with the firefighters and the police, but the issue hasn't come up yet in collective bargaining.
Thank you for being so informative.
Sure.
All righty. All righty, Doug,
Yes.
thank you very much. I found this all very enlightening and fascinating, as I always do with our conversations.
Thank you.
And sounds like other people did as well. So thank you very much for joining us. Thank you all for joining us to hear Doug today. I know there's a lot of attorneys on the call, so I hope what I'm saying is not illegal, but we're happy that we have recorded this, and assuming Doug doesn't have an issue, we'll be sending it out. We've had attorneys before, no one's ever had an issue, but someone told me yesterday I should get a disclaimer from everyone who ever speaks.
That's fine. That's fine.
So thank you. We'll be happy to send that out and reach out to Ariel. I'm going to put her email address in the chat. And again, thank you all for coming. It's been a pleasure to see you today.
Just reading all my accolades in the chat. Thanks, Gershon.
Yes, see, it was really excellent.
Sure. Thank you. Thank you, everyone.
Thank you very much.
Sure.
Thank you. Great presentation.
Thank you. Thank you.
Yeah. Enjoy the day.
Okay. Thanks. You too.
Yep. Bye-bye.
All right. Good day, everyone.